Good morning. I'm Daisy Glassburn, Chair of the Board of Real Estate Appraisers. Could you please take roll, Director Waters?
Daisy Glassburn,
Here.
Valerie Bartel,
Here.
Brent Goff. I can see him. Clint Taylor,
Here.
Rob Stylo.
He's muted.
Here.
Oh,
Sorry.
No worries. Bessie Chachas and Darius Wise are absent, but you have a quorum.
Thank you. Does any of the board members feel like they need to go into executive session before we begin the rulemaking hearing?
No. No.
No.
Okay, great. Today is Thursday, January 8th, 2026. It's now 9:01 a.m. This is a permanent rulemaking hearing pursuant to the Administrative Procedure Act found at Section 24.4.103 of the Colorado Revised Statutes to hear oral testimony and accept written submissions related to proposed amendments concerning the rules of the Colorado Board of Real Estate Appraisers referenced in the Code of Colorado Regulations as 4 CCR 725-2. Section 1210-6041AI of the Colorado Revised Statutes authorizes the Board of Real Estate Appraisers to promulgate and amend these administrative rules. This permanent rulemaking hearing is being conducted pursuant to the process as set forth in the Administrative Procedure Act. During this hearing, the board will hear testimony and accept written submissions in regard to amending Rules 9.2 regarding the portability of service member and service member spouse credentialing, and 11.3 with consulting services. In addition to my fellow board members, here with me today are Director Waters, Deputy Director Sarah Halloran, and Senior Advisor Melissa Phipps from the Division of Real Estate. Education, Communication, and Policy Manager David Donnelly and Karen Saffron from the Attorney General's Office. The public record will consist of all testimony and any written information submitted within the allowable time frame. Therefore, in addition to all of the public comments today, the board will review all written materials to make the final decision on the proposed amendments. The public record will close at the end of this hearing. Let's now have Director Waters explain the proposed amendments to Rule 9.2.
So board members, the federal law changed in 2025 about license portability for service members and service member spouses. So your current rule isn't consistent with the new federal law, but in looking at reciprocity, it's easier for somebody to come in just through basic reciprocity with us than through military credentialing, because standard reciprocity, they just have to have a credential and be in good standing. The state has to be in good standing as well in order for them to get a credential here. Whereas service member credentialing or service member spouse credentialing would require that person to provide us with military orders showing that they are being stationed in Colorado. And if it's a spouse, they would also have to show us their marriage certificate. So it's actually the federal law about service member credentialing makes license portability a little more onerous than standard reciprocity. And that is why we are suggesting that you just repeal that rule in its entirety.
Okay, thank you. Let's now have Director Waters explain the proposed amendments to Rule 11.3.
So board members, at your request, the proposed rule includes language from the statute itself, which is 12-10-602 sub 5. It also added some additional elements that pertain to the tax appeal process, just to clarify that those would also fall under consulting services as well.
Thank you for the explanation, Director Waters. At this time, we'll start the testimony phase of the rulemaking hearing. Excuse me. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you're representing, if applicable. Finally, please limit your testimony to only the proposed rule amendments and do not duplicate testimony. Should the board or any of its representatives have a question regarding your testimony, we'll ask when you've finished your testimony. If you desire to provide testimony, please raise your virtual hand so division staff know who to call on.
Thank you, board members. Once again, if any members of the public would like to address the board today, please select the raise hand icon in the Zoom platform. And looks like we have our first hand here. Betsy, I've asked you to unmute.
Can you hear me?
Yes, we can, Betsy. Thank you.
Oh, great. Sorry. Perfect. Well, I want to thank the members of the board for the opportunity to speak. My name is Betsy Wagner, and I'm a certified general appraiser. I began studying policy and real estate while pursuing my dual MS and MBA at CU Boulder nearly 2 decades ago, and I've worked as an appraiser since 2013. And today, I urge the board not to revise the rule by inserting statutory language verbatim. The rule is already clear, fully aligned with the statute, and references the law directly. Copying statutory text into regulatory rules creates duplication, maintenance burdens, and risks conflicts if the statute changes in the future. The rule currently cross-references the statute, which is the preferred policy approach that allows for maintaining clarity and flexibility without unnecessary future amendments. Both USPAP and Colorado statute are the guiding regulations for appraisers, and both distinguish appraisal from consulting service, as well as advocacy and other valuation-related work. Licensees already understand these regulations, and the rule is enforceable as written. It's also important to recognize recent changes in USPAP regarding consulting specifically. USPAP no longer mentions consulting as a recognized assignment type. This change clarifies that USPAP applies only to assignments involving an opinion of value or appraisal review, not to a broader advisory services. This helps prevent confusion for clients and licensees, ensuring that everyone knows when USPAP compliance is required. By aligning our rules with USPAP's updated language, Colorado maintains clear enforceable standards consistent with national practices. And it supports effective regulation and transparency for the public as well. When USPAP applies, it's because the assignment involves an opinion of value. When it doesn't, appraisers can clearly state that USPAP compliance isn't required, building trust and avoiding confusion. Just as I would advocate that cross-referencing statute rather than repeating it is the best strategy, USPAP's update in 2020 to remove consulting from USPAP's documentation streamlines the standards and reduces unnecessary duplication. These principles, clarity, consistency, and sound policy benefit both licensees and the public. And for these reasons, I ask you not to keep the rule as it currently is written and not adopt the proposed revision, given it merely just duplicates what's already stated in statute. Thank you for your attention and commitment to effective policy.
Thank you for your testimony. Any questions for the speaker?
If any other members of the public would like to raise their hand to address the board, please do so now. With that being said, board members, I'm not seeing any other hands at this time.
Okay, thanks, David. That ends the testimony portion of the hearing. We will now consider the proposed amendments to Rule 9.2. Do I have a motion concerning the adoption of proposed amendments to Rule 9.2?
Daisy, this is Rob. I motion.
Thanks, Rob. Do I have a second?
This is Valerie. I'll second.
It is moved and seconded that the proposed amendments to Rule 9.2 be adopted. Any discussion? Okay, the question is on the adoption of the motion that the proposed amendments to Rule 9.2 be adopted. All those in favor say aye. Aye.
Aye. Aye.
Aye.
All those opposed say no. Okay, the motion carries. And the proposed amendments to Rule 9.2 are adopted. We'll now consider the proposed amendments to Rule 11.3. Do I have a motion concerning the adoption of proposed amendments to Rule 11.3?
This is Board Member Goff. I make a motion that we have some discussion.
This is Clinton Taylor. I also second that motion.
Okay, great. Let's have a discussion then.
So
I-
as the
I-
assessor,
Oh, go ahead, Brent.
yeah, as the assessor member, I'd like to hear from my other board members first.
Can I just jump in for a point of clarification? I mean, it's fair if you want to have some discussion. Typically, it's you have a motion on the table and then you discuss that motion. And a motion for discussion is not something that's normally done. Normally, it's a motion to either adopt or reject. You can discuss and then you can vote on that motion, and then that's kind of a little bit more typical, but I'll leave that to the group. So it's because when you vote, your vote is going to be yes or no on whether or not to have discussion.
Brett, do you want to revise your motion possibly?
So I need to make a motion to have discussion. All in favor?
Well, I believe the motion needs to be to adopt or amend the board rule. And then after that, we can have some discussion and then possibly change what that motion is. Is that correct, Karen?
That's correct.
So if we have questions first, we reject it and then discuss and then go back and revisit.
No, typically it's you would have a motion, so somebody would either make a motion, let's say, to adopt or to reject, or whatever motion you want to make on the agenda item. You would have a second. If there's no second, then that motion fails. Once you have the motion and the second, the next step is discussion. And that's the point where you have your discussion about the merits of the matter. Once you're done with your discussion, then you would have your vote on whether to adopt or whatever the motion is. But if you're
We can
asking
adopt,
for a
reject,
motion,
or table it. Sorry,
yeah,
go ahead.
yeah, if you're asking for a motion to have discussion, then what you're doing is you move to have discussion, and the discussion is on whether or not to have discussion, and then the vote would be on whether or not to have discussion. So it's just a weird process hiccup. So
Yeah, essentially the motion is to open up the forum for discussion based on a certain motion. So if I could get a motion to adopt, reject, or table the proposed amendments to Rule 11.3.
This is Clint Taylor. I think we need to make a motion, or I make a motion to table for further discussion on Rule 11.3. Does that work?
I have a motion to table the proposed amendment to Rule 11.3. Do I have a second?
I'll second.
Let's see, who was that?
Bessie Chasis.
Oh, hi. Thanks, Bessie.
No worries.
Okay. I have a motion and a second. Is there any discussion? Now we can chit chat about it. I really appreciated the public comments over this. It was very helpful for me, and reinforces what my thought was, what in terms of the statutory language constrains the board from regulating this topic effectively and in terms of the language in the statute is problematic, but we cannot override or change that. So there were a few public comments made in terms of that last line in there, and at this point, I believe removing the statutory language out of the rule. That's what my suggestion is. Anyone else?
I mean, I don't have anything constructive to add other than I totally agree. And I really did appreciate the public comments that sort of illuminated the potential issues with adopting that.
I would agree.
So in tabling this, however, is there a timeline, or does another motion need to be made to effectively reject the amendments?
I have
So
a
do you want to
comment
reject
first.
them in their entirety? Because there was some additional language added that's not in the
That's
statute that speaks to the tax appeal process.
Okay, so and you're right, that so we would be adopting it in portion? Would that be accurate?
Well, so you could amend the language. And I'm thinking that based on what you have said, so if you start with the red line portion, you could say consulting services include counseling and advocacy in regard to property tax assessments, protests, appeals, and abatements of property tax assessments, and just leave it at that. Is that what you want to do?
That was my thought. Is that consistent with everybody else?
Could I make another comment, please?
Yes.
So this is Board Member Goff, and I'm the assessor member here. And I wanted to say I really appreciated the public comment. We have a real difficult job here. Our goal on this rulemaking is to make meaningful regulation in plain language, make it easy to understand and easy to follow. So with those goals in mind, when the statute itself is difficult or conflicts with USPAP, our job is it's difficult to almost impossible to make it meaningful and easy to follow and understand when the statute conflicts with USPAP, which it does. Advisory Opinion 21 is real clear that valuation services, when not acting as an appraiser, that would be ad valorem tax consulting as an advocate. So the statute says that it's a service performed by an appraiser under consulting. So with that in mind, since there's a conflict between statute and USPAP, I think it's impossible for us to clear up that conflict with a rulemaking. So I would recommend that we do not adopt the changes. And I really appreciate the public comment. And that was very helpful. So I'd make a motion that we do not adopt the changes.
And Brent, as to Marcia's comments, you, in terms of the tax assessment language that was added, that was not statutory language, that would, are you saying that you would want out as well, or no?
Yeah, I think my initial goal was to try to illuminate the fact that there's more to property tax agency than just appeals. There's opportunity for services to be provided for abatements, also for protests, along with the appeals. The appeals is a distinct part of all that due process. It's the second step in the due process. That being said, I think my initial goal was to try to illuminate the statute, and I think it's impossible to do so after listening to the feedback from the appraisers who gave it. I really appreciate that. The conflict is with the statute versus USPAP, and we can't overcome that with a rulemaking clarification. So I would make a
Marcia,
motion.
you were, oh, sorry.
Yeah, I'd make a motion that we don't adopt the rule changes.
And can I just jump in on a point of order? You've got a motion pending to table. And so Board Member Goff, are you offering an amendment to the pending motion to change it to reject? And if so, I think it was Clint who made the motion to table. Would you accept that amendment? I mean, it's just, I know it's weird. We're doing some weird gymnastics, but I'm just trying to keep everybody in line on one thing so that when you do come to a vote, it's clear which motion and what you're voting on.
Okay.
If the motion is to table, do we need to have a vote, or can we just alter the motion?
Well, you can have a vote and then have a new motion,
Okay.
assuming that you don't table. If you table, then you can't go forward. Or if you accept this as an amendment to the motion that's on the table, the person who made the motion has to agree. And then you can, if you get a second, then you can, you can proceed on the new motion to reject.
Okay. Previously, also, Marcia, we had discussed that bringing this up during the sunset review, which, just to clarify, that's the only means the division has to bring up things to the legislature about statutory language. Is that correct?
I think given kind of the banality of the statute, I think it's only going to come up during a sunset review, which if you table this, the rulemaking process, the permanent rulemaking process has a 180-day time frame. That's not going to happen during the next 180 days, just like they're not going to choose USPAP in the next 180 days. So tabling it is just going to make it die quietly. If you decide to reject 11.3, that's fine. It will stay the way it is currently. And then I will file the amendments to 9.2 that you did adopt today.
I have a question.
Yes.
Is there any way that we can revise it in this 180 days? Allow for public feedback and then bring it back up at sunset?
So we can definitely flag it for sunset. I think the overwhelming feedback was that they don't like the statute language being written into the rule, which you can take that out. And I had offered that you just keep the language that Board Member Goff had recommended at the last meeting, but that doesn't seem to be kind of appealing to the board either. So if you don't address it, it's just going to go like it will die a slow death.
Okay, that's what I wasn't sure if that was going to be something that just eventually ends up, because if we revised it, put it back out to the appraisers, to the general public, and allowed them to have more public opinion, would that be okay to allow them to have more public opinion on our revision of it?
Well, they were given the opportunity. That's part of the rulemaking process. They were given kind of 2 bites of the apple to provide you with comments. One was at the stakeholder meeting that we scheduled last month. And then this process in general allows written submissions and also public comment. So it would be kind of cleaner if you guys don't like the rule, and if you want to listen to the feedback, then just reject it. We'll move forward with the changes to 9.2. And if somebody would like to recommend changes later on to this, to 11.3, we can kind of start this process again.
Marcia, in that line of thought, is if it were to be rejected right now, the only way it comes to light again is if the board brings it up again, or how do we ensure that it is brought up at the sunset review, not knowing when that is, but.
So I think your next sunset review is in a couple years.
Yeah.
And it's like we keep a running list typically of problematic issues so that it gets flagged during the sunset review. So I can add it to the list. And with rulemaking, anybody from the industry can recommend changes to rules. We do periodically go through rule reviews, which your board will go through one. We'll probably do it in 2027 because we're going to do the MLO board in 2026. So there will also be that opportunity to kind of review the rules then.
Okay. Brent, I just want to clarify, you are the initial language that you wanted added, you do not want added now?
Yeah, thank you. So I listened carefully twice to the public comments that were given last month and also today. And I'm of the opinion that a rulemaking here it wouldn't meet the goals of providing meaningful regulation in plain language that's easy to understand and easy to follow. The conflict between the statute and use path is impossible to overcome without a change in the statute, and we don't have the juice to do that. That's our legislators need to change that language. So I don't want to put this in our rules because it doesn't meet the goal that I had,
Okay.
which was to help illuminate what was in the statute.
Okay, I understand. So in this incident, unless there's other comments, possibly, and correct me if I'm wrong, Karen, if Clinton or wants to either revise his motion or we need to vote on his motion to table first.
That's correct. So you can amend the motion. You can accept Board Member Goff's suggestion as a request to amend the motion. Because Board Member Taylor made the motion, it's up to him to accept whether he'll agree to that or whether he wants to just proceed on his original motion. And so it's the ball's in your court. And then if no, then you vote on, then you can on the tabling. If the tabling motion fails, then you can have another motion to either accept or reject. Because then if the tabling motion fails, then the matter is still on the table for consideration. So you can do it as a two-step, or you can do it as a two-step or a one-step. And then to Marcia's point, if this is tabled, then you've got your 180-day time period, and this may die a slow death. So I guess those are your three choices.
Okay, Clint, any thoughts?
I feel like recommending to support what Brent is recommending, I think is the direction I would like to go to amend. So I would make so I guess basically my motion is to amend the language and support what Brent Goff is recommending. I guess that's I'll just leave it at that.
You're making a motion to amend your initial motion.
Yeah,
and
sorry.
Wanting to reject it then?
Yes,
Is that
yes. That's
Yeah,
correct.
Clear.
Yeah. So I make a motion. This is Clint Taylor. I make a motion to reject.
So just to clarify, so Board Member Taylor, you're accepting the amendment, so Board Member Goff's motion is now the one that's on the table.
Correct. Thank you for your help in
No, it's a
that.
mess. I'm sorry.
No, it's okay.
Blame Roberts.
It's a little confusing, but we're getting there.
Thanks, Karen. So I do have a motion then to reject the amendments to Rule 11.3. Do I have a second?
I'll second.
Was that you, Bessie?
Yes.
Okay, sorry.
No worries.
I have a motion and a second. All those in favor say aye.
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 I,
All those opposed say no. And the motion carries. And the amendments to Rule 11.3 are rejected. And this concludes the rulemaking hearing. Thank you. Okay. Need just a second here. We will move to the regular meeting. And this is Daisy Glassburn, Chair of Board of Real Estate Appraisers. Today is January 8th, 2026. It is now 9:31 a.m. This is a public meeting of the Board of Real Estate Appraisers. We will now call this meeting to order and begin by having the division director perform a roll call.
Daisy Glassburn,
Here.
Brent Goff,
Here.
Bessie Chachas,
Here.
Valerie Bartel,
here,
Clint Taylor,
Here.
Rob Stylo.
Here.
Jurius Wise is absent. You have a quorum.
Thank you. Okay, can I have a motion to approve the board meeting minutes from November 6th, 2025?
What date was that? I'm sorry. Daisy, can you say that again?
November 6th, 2025. Let's see. That should be correct. As far as what I'm seeing.
yeah, that date is correct. I was not present at that meeting, so I don't know that would be appropriate for me to vote on that.
Make the same vote on that one.
I was at the meeting. I don't know why I didn't show up, but I'll go ahead and go for the motion of that, please. Oh no, I didn't show up.
Okay, thank you. I have a motion. Do I have a second?
This is Rob. I second that.
Thank you, Rob. There has been a motion and a second to approve the meeting minutes from November 6th, 2025. I'm assuming there is no discussion. Is there any discussion? Okay, there's been a motion and a second to approve the meeting minutes of the November 6th, 2025 Board of Real Estate Appraisers. All those in favor say aye. Aye.
Aye.
Aye.
Aye.
Those opposed say no. The motion passes. Okay, next order of business. We will move to policy matters. Arsha?
So board members, really quickly, I just wanted to give you a staffing update. Garrett Lyle left us in November. He took a job with Secretary of State. Sarah Holleran is now the new deputy director. She's been with the division, I think, for about 15 years, if not longer. She was the team lead for our largest group of investigators. She had 7 that did investigations for the Real Estate Commission and the Board of Mortgage Loan Originators. She's got a background in real estate and also mortgage. So at some point, I will transition your investigators over to her. We are in the process of filling her old position and kind of getting her bearings. So I am taking over in the meantime and managing the appraiser investigators, but at some point she will take those duties over as we get her vacancy hired and kind of lighten her load. So please welcome her, and she's on this call today.
Welcome, Sarah.
Thank you. I look forward to working with you.
And then other than that, is there anything that you would like placed on your agenda for March?
I don't have anything.
Yeah, I don't either.
That's quite all right. So that takes us to the citizen participation period.
Okay, thank you. Any person may bring their concerns about matters not on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless allowed additional time by the board. Is there anyone who has signed up to speak?
Board members, no one has reached out in advance of meeting so as to speak. However, if anyone would like to address the board, once again, please select that raise hand icon in the Zoom platform and we can identify you. So with that, board, if we can just give it a few seconds, see if anyone raises their hands. However, I'm not seeing any. So back to you then. Thank you.
Thanks, David. Next, we'll move to complaint matters.
So board members, complaint matter A is case number 2025-1794. Rob Walker is the investigator of this complaint. The complainant allegations of failure to properly verify building permits and to complete a assignment in a timely manner did not appear to have merit. However, when reviewing the report and work file, there appeared to have been numerous potential USPAP violations of the scope of work rule, record keeping rule, and standards rules 1 and 2, as well as board rules and state statutes. The respondent failed to adequately research and analyze the current market conditions and comparable properties. The report also failed to adequately describe the subject's conditions and improvements, nor did it include any of the criteria or commentary regarding the selection of the comparable sales. In the sales comparison approach, there was no analysis or documented support for the adjustments, nor was there any support for the site value and the cost approach. Additionally, there were numerous factual errors and contradictory statements. Possible violations include 12-10-6131B, 12-10-6131G, Board Rule 12.12, the Scope of Work Rule, the Record Keeping Rule, the Competency Rule, and then Standards 1 and 2. The recommended discipline is a stipulation for diversion, a $500 fine, a work product review of 2 appraisals in 2 months, and then coursework in the sales comparison approach, site valuation, and the 15-hour USPAP. And just to note that in 2024, the required coursework that this respondent had to complete as a result of another complaint was 7 hours of comparative analysis and supporting adjustments and the board's reliable record keeping course. Rob is here to answer any questions that you may have.
Thanks, Marcia. Do I have a motion to accept the staff's recommendation?
This is Valerie Bartel. I will make a motion.
Thanks, Valerie. I have a motion. Do I have a second?
Sorry, this is Rob Stylo. I second that.
Thanks, Rob. I have a motion and a second. Is there any discussion, questions for the investigator? No questions or discussion on this one from anybody then?
No.
Okay. I have a motion and a second to accept the staff's recommendation. We'll now take a vote. All those in favor say aye. Aye.
Aye.
Aye.
All those opposed say no. And the motion passes.
So board members, complaint matter B is case number 2025-2005. Rob Walker is the investigator on this complaint as well. There was no merit to the complainant's allegation that the respondent did not personally inspect the subject property, but the allegation of inappropriate comparable selection due to condition and location appeared to have merit. Additionally, when reviewing the report and work file, there appeared to have been numerous potential USPAP violations of the scope of work rule, record keeping rule, and standard rules 1 and 2, as well as board rules and state statutes. The respondent failed to adequately research and analyze the current market conditions and comparable properties. The report also failed to adequately describe the subject's conditions and improvements, nor did it include any of the criteria or commentary regarding the selection of the comparable sales. In the sales comparison approach, there was no analysis or documented support for the adjustments. Potential violations include 12-10-6131B, 12-10-6131G, the scope of work rule, record keeping rule, and standards rules 1 and 2. The recommendation is for a stipulation for diversion, a $500 fine, and coursework in the sales comparison approach, reliable record keeping, and supervisory appraiser and trainee appraiser course, because she is training somebody. And then Rob Walker is here to answer any questions that you may have.
Thanks, Marcia. Do I have a motion to accept the staff's recommendation?
It's Clint Taylor. I make a motion to accept.
Thanks, Clint. I have a motion. Do I have a second?
This is Valerie Bartel. I'll second.
Thank you, Valerie. I have a motion and a second. Is there any discussion on this one?
I have a question. Marcia, this
Go
is
ahead.
Board Member Goff. The person under complaint here is a certified appraiser. And during this investigation, it was found out that she had a trainee involved. Don't they have to have the supervisory training course before they do that?
Not in Colorado, because we don't have a trainee credential. So because we don't have a trainee credential, we can't require supervising appraisers here to complete that course.
Okay. Okay, thank you.
Are there courses approved within Colorado for that she's going to be, the part of the recommendation is to take that, correct?
So I'm not sure if the one that I recommended is actually approved for CE here, but I did just try to find one that was available to the industry that spoke to that topic.
Okay.
Also to keep in mind though, when you order them to take coursework and it's through a stipulation, they don't get to count that as continuing education credit. So it's the importance is that they're getting the education.
I just wanted to make sure that there was options in terms of the course. Anyone else have any questions or comments?
Yeah, I was just thinking of a follow-up on this. If you had a situation where you had a certified appraiser supervising a licensed appraiser, I think it'd still be appropriate that they would take the course that is necessary to be a supervisor. I don't expect any action on that. It's just a thought that if you have a superior license and you have a trainee who has a inferior license and they're out training someone, it would be good policy for them to go through the supervisory training course.
I would agree with what Brent is saying, because I feel that anybody that just gets that licensure, so basically if they go from licensed to certified, in previous experience, I have noticed that some appraisers just take on a trainee. I almost feel like there should be some type of, I don't want to say rule, but some type of requirement, hours, years of service, experience, or instead of something like that, a class that should be put in its place to make sure that they are doing a satisfactory job of training a trainee, not just because they just got a license, if you will, or an upgrade.
I was under the impression that there was a number of years of service that you had to have before you could take on a trainee. Is that not correct?
Well, so for the states that have the trainee credential, there are standards, but because we don't have the trainee credential, those don't apply here.
Okay.
and I will tell you, when they first came out with the supervisory trainee requirements, we had tried to kind of put those in place for the supervisors, knowing that we don't have a trainee, and the appraisal subcommittee said we couldn't do that because we don't have a training credential.
Interesting.
Yeah, we got rid of the training credential a long time ago because we were already out of compliance with several of the ASC policy statements, and trainees are horribly bad, or it was our experience, horribly bad at completing their continuing education requirements, which is one area that the ASC can go after us for. Is we have to demonstrate that our pool of licensees has a 90% or better compliance rate with continuing education, and the trainees were kind of the lead weight that was dragging us down and not helping us hit that 90% rate.
Interesting.
But you're aware of a course that is an option
Oh
for
yeah,
this particular person.
so there's
Okay.
other states that have the trainee credential, and there's organizations out there and also schools that have the supervisory course available. So that's why I recommended that she take
Okay.
that course, even though like you could not adopt a regulation that says every appraiser in the state of Colorado that's going to supervise somebody has to take this course. You can mandate it through a disciplinary decision.
Okay.
Brent, did you have something?
No, that's interesting, Marcia. Thank you.
Okay. Hearing no further discussion, I have a motion to accept the staff's recommendation and a second. We'll now take a vote. All those in favor say aye. Aye.
Aye.
Aye.
All those opposed say no. And the motion passes. It looks like we don't have any licensing matters or ESP matters. For the Attorney General, we have an update on the Selhauer versus Boria lawsuits. So give me just a second here. This is Daisy Glassburn. It is January 8th, 2026, and the time is 9:48 a.m. This is a meeting of the Colorado Board of Real Estate Appraisers. I move that the board enter into executive session pursuant to section 246402 3A2 of the Colorado Revised Statutes to receive legal advice on the specific legal questions concerning the update on the Selhauer versus Boria lawsuits. Do I have a second on the motion?
This is Board Member Goff. I'll second.
Thank you, Brent. I have a motion and a second. All those in favor say aye.
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 All those opposed say no. And we will move into executive session. We have 5 votes. Everyone can go to the Google Hangouts. Let's see. Is everybody here? Looks like it.
Looks like it.
Okay, the time is 10:06 a.m. and the board is now back in open session. Really, that's the last item on our agenda. Can I get a motion to adjourn the meeting?
This
Board
is
Member
Rob.
Taylor, I motion to end the meeting.
I have a motion. Do I have a second?
This Rob, I second that.
Thanks, Rob. I have a motion and a second. All those in favor say aye. Aye.
Aye.
Aye.
Great. The meeting is adjourned. See you all in a couple months.
Thank you.
Thank you, board members.
Bye,
Aye,
guys.
take care, guys.
Thanks.